Okay, I'm gonna go off for 5 seconds.
We have Mark Augusti too. Okay.
Okay, are we ready, Alexandra?
I believe so.
All right, well, good morning, everyone. I'm Bob Hunter, Chairman of the North Carolina Property Tax Commission. Welcome to today's Tuesday, October 19th, 2021 session. Everyone the commissioners have the notice about any conflict or appearance of conflict on your agenda. If anyone has one, please let me know now. Seeing none, all right. We're ready to proceed with today's agenda, which will include a case from Wake County, which we mistakenly had on yesterday's agenda. But we have it, and we'll probably do it first. Mark Augusti. And then we have 3 cases from Cabarrus County. And then we have a case from Durham County. And we did have a case from Onslow County, but that case at the request of the taxpayer has been continued to our next session. So at this time, we will have the Wake County case, Mr. Mark Augusti, and we have Kenneth Murphy, Wake County Assistant Attorney, representing Wake County. Is Mr. Augusti with us this morning? Alexandra, do you show him on any of our screens?
Yes, sir. He is the DOR October 2021 Mark Augusti person. I think he has on a green sweater.
I was gonna say I'm the inappropriately dressed individual. You guys all look great, and sorry I didn't put my coat and tie on this morning. I do own a coat and tie. I just don't have it on this morning. I apologize.
You're fine. We just normally wear ours. Probably wish we could be like you, but anyway, or even more casual. Sometimes these Zoom or WebEx meetings that you're on get pretty casual. But welcome, Mr. Augusti. We're glad to glad to have you. So we'll call this case at the first time. All of these cases today are on for motions to dismiss. That means we don't normally need to swear anybody for testimony, but they're all here on the file before us, and also any parties that have anything to present to us. So, Mr. Augusti, in matters like this where a motion has been filed by the county, they go first to explain their motion, and then we will hear from you as to your presentation on this motion. Their motion is to dismiss this appeal, and I assume you will be resisting that. So, Mr. Murphy, we'll hear from you at this time.
Mr. Chairman, did you want to introduce everybody?
Oh, yeah, thank you. Excuse me. I normally do that first, and I forgot to do that. So, yes, the commission members, everyone's present today, and our staff. Vice Chairman Terry Wheeler is with us, and then Commissioner Bill Peasley, and Commissioner Alex Guest, and Commissioner June Michaud. I've already introduced myself, and then our staff, we have Steve Pelfrey, our Secretary and General Counsel, Linda Garrett, our court reporter, and Alexander Bendet, our staff person and host for the meeting. So, Mr. Murphy, at this time, we'll hear from you.
Thank you, Mr. Chair. Good morning, Mr. Chair. Good morning, Commission members, Mr. Augusti. My name is Ken Murphy, Deputy County Attorney with the Wake County Attorney's Office. Mr. Chair, as you noted, this is Wake County's motion to dismiss Mr. Augusti's appeal for failure to timely file his notice of appeal within the time required by North Carolina General Statute 105-290. As the Commission knows, NCGS 105-290E requires that a notice of appeal to the Commission must be filed with the Commission within 30 days after the date that the county board mails its notice of decision to the taxpayer. And I filed a written motion to dismiss with exhibits attached and with an affidavit attached. I'll just briefly be referring to those exhibits this morning in my argument. In this case, the notice of the Wake County Board of Equalization and Review's decision was mailed to Mr. Auguste on November 17th, 2020, as noted in Exhibit A to the county's motion to dismiss, and the affidavit of Marie Fitzgerald from Wake County Tax Administration Department. Mr. Auguste filed his notice of appeal with the Commission more than 30 days later, on January 7th, 2021, as evidenced by Exhibit B, the acknowledgement letter from the Commission attached to the county's motion to dismiss. Now, pursuant to North Carolina General Statute 105-290E, the deadline for Mr. Auguste to timely file his notice of appeal would have been December 17th, 2020. Mr. Auguste missed this deadline by a little over 3 weeks when he filed his notice of appeal on January 11th, 2021. Now, the North Carolina Court of Appeals has held that this commission has no jurisdiction to hear an appeal unless the notice of appeal is timely filed. That's the N. Ray Bass income case with which this commission is well acquainted. In that case, the taxpayer's notice of appeal was received by the commission 1 day beyond the 30-day deadline required by GS 105-290E. In this case, as noted earlier, Mr. Auguste was a little over 3 weeks beyond that 30-day deadline required by the statute in filing his notice of appeal. So on the authority of GS 105-290E and the Bass Income Court of Appeals decision, Wake County would respectfully request that this commission dismiss Mr. Auguste's appeal for his failure to timely file his notice of appeal. And I'll be happy to answer any questions the commission may have.
All right, let's hear from Mr. Auguste, and then we'll see what questions and other information we might desire. And this is the file number of this case is 21 Property Tax Commission 0007. Mr. Auguste, we'll hear from you at this time.
I appreciate that. And obviously, Mr. Murphy knows the law and respect his position and argument. My only point that I would like to make to the commission is I did not receive the notice in a timely manner. So by the time I got it, it was late. The paperwork that I have and that I filled out just to show that is that I sent it on like December 29th, which I agree was still late per the timeline that Mr. Murphy outlined. But yet they're saying they didn't get it till January 7th. I think we all know that in this time there was some, challenges going on as far as communications and processes. So, I'm not going to dispute the facts that the appeal was late. All I'm saying is that my notice from the county didn't get to me in a timely manner either. So I didn't get the benefit of normally the full 30 days that was there. That's my only issue is I feel like it was there. I think it's also, I just want to know that Mr. Murphy, I'm not sure it's in the record, but I did pay the tax. So I have paid and I'm in good standing. And this is really more of a technical legal matter at this point for the commission. I think I might even set your office a note, Mr. Murphy, to say that, I paid because I don't want to be a bad citizen, but it is a little frustrating in the intricacies of these things that, we're forced from the standpoint to kind of respond to late notices in a more timely manner. And that was the part that was a challenge, because I thought I actually had a pretty good appeal. Having said that, I also realize now that probably property values have gone up and everything's sort of crazy. So I feel like in the real world, I'm not sure where we stand, and this is more of legal matters. But anyway, that's all I'll say. I don't know if the commission has any leeway, given that I don't think the initial notice that I got from the county was timely. It didn't it didn't get to me till well into the 30-day window. So it was very hard for me to respond in a timely manner.
Okay, questions from any of the commissioners? Don't see any. Mr. Auguste, this is one of those matters where the statutes which are adopted by the legislature and the court decision doesn't give the commission discretion if it's in fact late. That would have to be changed by the legislature. So our hands are tied in a matter if the facts are what Mr. Murphy's affidavit and presentation are correct. In some matters we have discretion. This is not one of those, as I understand it. Any other members or council? Steve, you have anything to add?
Mr. Chairman.
All right. Do I hear a discussion on this matter or a motion?
I'll make a motion to grant the county's motion to dismiss.
All right, I have a motion by Vice Chairman Wheeler. Is there a second?
Second.
Okay, Commissioner Peasley seconds. Any more discussion? Hearing none. All in favor of the motion, say aye.
Aye.
Okay, Mr. Augusta, this is, as I said, one of the matters where we have no discretion and we have to dismiss. I would point out to you, you can, I think the county will tell you, you can still appeal next year if you file it timely and get a session there. With the way property tax matters, as I understand them, and I have my daughter who lives in Wake County and just bought a house not too long ago. But the values that will be determined are based upon prior valuation values and not on the current one. So I think, Mr. Murphy, y'all had a valuation, what, 1 year or 2 years ago?
2020. So
So-
coming up on 2 years.
Yeah, so it would be based on the values as of that date, so you could still appeal, I understand, if you would like, for the coming year. I would like to take a moment of personal privilege, since Mr. Murphy is here. A tragic situation. His boss, Scott Warren, some of you may know Scott, was due to get married, I think within the last 2 weeks. His fiancee, who had been previously married, had a daughter. She was, I think, a senior at the University of Georgia, and was tragically struck and killed in a hit and run accident. I think 2 days before the wedding. They had to postpone the wedding. So, Ken, tell Scott we've got him in our prayers.
Mr. Chairman, I will be sure to do that, and he will very much appreciate that. So thank you.
So, Mr. Chairman, I would just like to thank the committee members for their time. Mr. Murphy, I'm sorry you had to take the time out on this, but I now understand the rules, and I'd just like to get an acknowledgement from you. Is that correct, that I have the opportunity, if I choose so, to appeal next year, which was basically this year, once I get my tax notice? Is that correct?
Mr. Auguste, you absolutely have the right to appeal each year when you receive that year's tax notice.
That year's notice.
That's correct.
Okay.
Right.
All right. Well, in any event, again, I appreciate all the work and efforts that you guys do. I'm sorry I wasn't in more formal attire, but thank you again for at least giving me my opportunity. And again, I'd just like to acknowledge I have paid the taxes, and always and will continue to be a good citizen of Wake County. So thank you very much.
Well,
Take
I'm
care.
sure you
Appreciate
are.
that on
And
behalf of the county.
thank you, Mr. Augusta. We were glad, and that's what we're here for. Sometimes we can help the taxpayer, sometimes we can't. But we have to go by what the statutes require us. Okay. Anything else in this matter? If not, thank you, Mr. Murphy.
Mr.
And,
Chairman,
yes, Vice Chairman Wheeler, I believe.
yes, Mr. Augusta, you still there?
He may be gone.
I think he logged off.
All right, I don't know if Mr. Murphy, whether it was clear to him. He said I can appeal when I get my notice. Isn't it true he should appeal before the Board of E&R adjourns?
That is correct.
Yeah, he won't be getting a notice. So if you could pass it on to him so that he really understands, because he may be waiting for his tax bill and that may be too late.
Good point.
That's a good point. Yes, I will follow up with our tax administration department and have somebody reach out to him to make sure
Thank
he's
you.
aware of that. Yes, sir. Thank you.
Good point, Terry. Thank you. All right.
Mr.
The
Chairman.
next matter before us is Cabarrus County, and Mr. Richard Cook is the county representative, county attorney's office there, and we actually have 3 cases. American South Management Company, 21 Property Tax Commission, 0188, and then Central Piedmont Management LLC, 21 Property Tax Commission, 0189. And then Overcash Real Estate LLC, 21 Property Tax Commission, 0187. And all those, I think the appellate, it's the same individual appearing pro se for those companies. And I believe it's Mr. Overcash. Is he with us?
Yes, sir. We have Mr.
Yes, I am.
Overcash, Mr. Koch, and Mr. Thrift.
Okay, I see Mr. Koch's indication, and I see Mr. Overcash. And who was the other one? Oh, David Thrift. Okay, and he just moved on me. When I moved my cursor, I think. And Mr. Thrift, I believe you're with Cabarrus County. Is that correct?
Yes, sir, that's correct.
Okay, I guess we need to hear these matters individually. I don't know if there's, I've looked at them. I don't know if there's any differences in them, but we will take them individually. The American South Management Company, it's the first one I have, 21 Property Tax Commission, 0188. And so this is here on a motion to dismiss filed by Cabarrus County. And Mr. Overcash, what we do in these matters, I don't know if you heard the other one, but the county goes first since they filed this motion, and then you'll have an opportunity to respond for this matter.
Okay.
Mr. Cook, we'll hear from you at this time. Mr. Cook, excuse me, Mr. Cook,
Thank you.
hear from you at this time.
Thank you, Your Honor. I'm here as the county attorney for Cabarrus County, and we have actually filed, I think it's a total of 12 motions to dismiss, and 2 of them are in this first case you've called, which is the 0188 case. That's the American South matter. We've got 2 motions to dismiss for the 2 properties that Mr. Overcash has appealed in that matter. Actually, all of our motions are the same because all these matters were heard at the same time. So when I talk about the time limits in this matter, it'll apply to every motion that we have in all 3 cases.
All right, let me interrupt you there for a second. Mr. Overcash, do you want us to hear all these at one time if they are all involving the
I think
same
so.
situation?
It's all, I mean, yeah, I was there for all of them at the same time, and it was delayed for the same, all of them were delayed for the same reason, so.
Okay, all right, we'll go ahead then and we'll here, all of them, let me just announce them again. We just announced that one, the American South Management, the Central Piedmont Management LLC, 21 Property Tax Commission, 0189, and the Overcash Real Estate LLC, 21 Property Tax Commission, 0187. We'll consolidate those for the purpose of this hearing and consider all the motions and presentation from the county to apply to each one of these, and Mr. Overcash's testimony to, or not testimony, but presentation to apply to each. For this purpose, Mr. Overcash, we don't require anyone to be sworn unless we get into some factual
Okay.
dispute that we actually need sworn testimony. All right,
Yep.
go ahead, Mr. Cook.
Okay, thank you. I'll start out really with 0187, because that's the one in which there are 9 properties that have been appealed. And that's the Overcash Real Estate LLC matter. And we filed verified motions in all of these cases. And we set forth the time limits. This matter is actually, all of them are very similar to the one you just heard from Wake County. It's a late filing of the appeal. So the same, statutes under 105-290 would apply, and the same cases. But in this matter, the time periods are that on December 15, 2020, Mr. Overcash appeared at our Board of Equalization Review and contested the value. And I'm talking first about the Overcash real estate cases, 0187. And so he was there, and he contested the values on 9 parcels under that LLC, and the board affirmed the values that the tax administrator had. And then a notice of decision for each of those parcels was mailed by the Board of E&R to the taxpayer on January 15th, 2021. And that is using the same form that the Department of Revenue authorizes for local counties to use to notify. It has all the information in there about how to appeal and what the time limits are about appealing. And those notices are actually attached to the AV-14s that the taxpayer actually filed in these cases. So those were mailed on January 15th, 2021. And of course, it says that you have to file your appeal within 30 days of that date. And those were each sent to the taxpayer. And like I say, they're attached to his AV-14s. The taxpayer's AV-14s in all those cases show that they were actually completed and signed by the taxpayer on March 14th. So that was basically 2 months later. Then there was a letter sent from Mr. Pelfrey acknowledging the appeals in each of these cases. And it says that letter was sent on March 31st and states that the appeals were received by the Property Tax Commission on March 23rd, 2021. So more than 2 months after the letter, the notice of decision was sent by the county. So that's those are the time limits in these cases, and they're obviously late, beyond the 30 days. And say we have a motion that has been verified that we submitted in all these cases. I've talked about the 9 from Overcash Real Estate. That's also the situation with reference to the 2 American South appeals. And then there's 1 from the Central Piedmont entity that rounds out the 12 appeals and 12 motions to dismiss. So that's the situation that we have with all these appeals. They all are in the same situation legally. And That's why we filed a motion to dismiss is because they are late, and under the statutes and under the cases, as you're well aware, the board doesn't have any jurisdiction to hear the appeal if it's not timely filed.
Okay, anything else, Mr. Cook? I keep saying Cook.
That's all right. It's what it looks like. So,
Yeah, and I'm looking at it's underneath your picture here, so I keep looking. All right,
afflicted with that all my life. So
I bet. Okay.
it's fine.
All right, Mr. Overcash, we'll hear from you at this time, sir.
Okay. So my company, Overcash Real Estate, I think mainly is they end up having to have 3 different hearings. I was there at the hearing. A set of them was never heard. They pushed it off, saying, well, we're going to have to reevaluate this as a whole thing. So I was holding all my documents until I got the notice of hearing for it. But they basically delayed it, and then they didn't send me the notice of decisions until March 26th on 3 of the parcels, and then another one that never even been heard. So the commission staff is really why it was delayed. I finally just sent it out, but I was waiting for those last notices of decisions because it considered it as a whole. Like there's 3 parcels, 1 storage facility sits on with Overcash Real Estate. And so that's the reason why they weren't sent within that 30-day time period. But that's the only reason that I know it's still not 30 days, but it was held up. All of the applications or applications for a hearing was delayed for that reason. And I don't know if that's a good enough reason or any reason, but that's why I was delayed. And I'm trying to get that, get these heard still. But yeah, that's all I have.
You're muted, Mr. Chairman.
As I understand it, Mr. Overcash, there were some appeals that you did get filed timely. I think perhaps 3 you said, and there's 1 more that you haven't gotten a decision on. Was that? Did I hear you correctly on that?
I think I've gotten it now.
Okay.
Yeah, at the time of this email that I'm looking at, but it was almost April by the time the last property was heard, and I didn't get the final notice of decisions from 3 that they put off during the Board of Commission meeting. I didn't get those until March 26th. So I sent it out before I even got those, knowing that I probably was going to, I wasn't within my time limit.
Okay. But there are 3 that I assume are pending before us that will be heard at a later date. There's no motion or anything on those, Mr. Cook. Is that correct?
No, Judge, there aren't.
Okay. So we'll have those before us, and I assume the other one is somewhere in process that you mentioned. Any questions? Mr. Cook, anything else from you?
No, Your Honor, I think that's all.
Mr. Guest.
Question for Mr. Pelfrey. And I would like for him to confirm for us that the parcels that were timely received, what numbers they were, and that they are not part of today's hearing.
Yes, Mr. Guest. In file number 21 PTC 0187 Overcash Real Estate, there were a total of 11 parcels associated with that owner. 9 of those parcels our office identified as potentially being untimely. 2 of the parcels we identified as being apparently timely, and those parcels were we are showing them as parcel number 5613944614, and then there's 4 zeros at the end, with a street address of 1631 Dale Earnhardt Boulevard. And then the other parcel that appeared timely filed It's parcel number 5613943780, and then 4 zeros at the end. And that is shown as having an address, a street address of 1621 Dale Earnhardt Boulevard. So those were the two parcels from 21 PTC 0187 that appeared to be filed timely, and according to Mr. Cook, are not included in the county's motions.
That's correct.
Okay,
And-
good
and-
point.
Thank you.
Good point, Mr. Guest. Steve, Mr. Pelfrey, let me ask you, is there a way that we can pull those ones out that are timely and give them a new designation so they don't get confused, since we're gonna apparently be looking at a motion to dismiss in this case number?
Yes, sir. I can speak with the staff and find out the best way to do that. But I know in the past we have been able to add, a letter or something at the end of a file number, maybe just reassign a file number for those two parcels in order to avoid confusion on that. I don't think that'd be a problem one way or the other for us to segregate those parcels.
Okay,
And if I could just
Go ahead.
clarify with Mr. Overcash, Mr. Overcash, you mentioned that there was a delay from commission staff in getting the documents and so forth. By that, I take it that you mean the county staff and not the property tax commission staff. Is that correct?
Correct. Yes.
Okay. Thank you for that.
yeah, and I thought that was the case. Good point. All right, is there one other case that we're still dealing with, Mr. Cook, Mr. Overcash, Mr. Pelfrey, that needs to be addressed with this? Is it floating somewhere?
Mr. Chairman, I could speak to that. There
Okay.
is 21 PTC 0190, but that was, I believe Mr. Overcash mentioned a third parcel. That is actually in his name personally, Alan Overcash, but that appears to be timely as well. So
Okay.
I believe that with the two parcels that we just mentioned are the three parcels that there doesn't appear to be an issue with timeliness on.
Okay, then is that everybody's correct understanding, Mr. Cook, Mr. Overcash?
Yes, Your Honor.
Okay.
Yeah.
So, well, let's go ahead and discuss this motion after I hear from, I see Mr. Guest.
Mr. Pelfrey, the third party that you're referring to, the parcel, is that 5613944558 with 4 zeros at the end?
Yes, Mr. Guest, that is what I'm seeing on the notice of appeal that was filed.
And that's in Mr. Overcast's personal name.
Yes.
Thank you very much.
Okay, any more discussion on this matter? Hearing none, do I have a motion?
Your Honor, I'll move that we dismiss for untimeliness the parcels that were not timely filed in all cases.
Okay, and do I have a second for that?
Second.
All right, and just so we'll be clear, which ones we're dismissing. I think 187, we're dismissing 9 partials, and 2 of those are not being dismissed. And then we're dismissing 188 and 189. Is that correct, Mr. Pelfrey? And Mr. Cook, Mr. Overcash?
Yes, Your Honor.
If this motion passes. Okay, so that's the motion. Any further
Yeah.
discussion? Seeing none, all in favor of the motion, say aye.
Aye.
Opposed, no. And the motion carries unanimously. Mr. Overcash, if you heard the other case, this is one of those where we have no discretion. If it's untimely, we have no jurisdiction, and the statutes, which are passed by the legislature, in which we have to go by, and the court decision affirming that, that we are bound by. So in this case, we have no discretion. You can, if you heard the other matter, you have the opportunity to appeal for the coming year when the proper time is there, but don't wait for your tax bill. There's a timeliness that you're probably aware of that
Yeah.
you need to file it by if you want to refile those. And we will be seeing you for the other cases when they're put on the agenda. Right now, we're virtual. We hope to go back to in person as soon as we can. And so you'll have an opportunity for a hearing on those cases when they're scheduled, and you'll get notified about those.
Okay.
Mr. Pelfrey, anything you need to add?
No, Mr. Chairman.
Mr.
All right.
Chairman.
Anything
It-
else, Mr. Pigsley?
Yeah, I don't know the nature of those 9 properties or the 3 that we will hear in the future. And this is just my personal opinion. I don't know how the other commissioners feel about it. When it comes to valuation, unless the properties are very similar, like all of them are vacant land, I find it very difficult to have multiple buildings and multiple parcels and us render a decision when the only commonality is the 2 parties. But like I said, it appears we had quite a few parcels under one case number, and we were going to hear them all en masse had the motion to dismiss not succeed. And I personally frown upon that, but I'll leave that up to other commissioners. I think the default should be if it's a separate parcel, it's a separate case, and then subject to a motion to combine them if there was some reason for it to be, more commonality than just the 2 parties. But
That's a good point, Steve, and maybe we can discuss that tomorrow during our administrative session. As to, you can educate us a little bit about that, and we can have some input on what may be best practice. Anybody else have anything on this matter?
yeah, I would just say it sounded like it came out of the Board of Adjustment
Right.
as being a combination of a bunch of properties. And we may want to, and after our discussion tomorrow, we may want to send a signal to them that says, unless there's a lot of commonality, these are almost identical pieces of property. Don't send it up as one, but
Yeah,
we can talk about that tomorrow.
right. Good. Okay. Good point. Okay. Well, thank you, Mr. Cook, Mr. Overcash, and Mr. Thrift.
Thank you.
Imagine we'll be seeing you in the future. All right. We have then it looks like a case from Durham County, and the last case that we had from Onslow County has been continued. So I think this is the last case we have, and it's Cisco Systems Capital Corporation versus Durham County, and it's here on a motion to dismiss. So I see Mr. Waddell here, and do we have someone here on behalf of Cisco Systems?
It does not appear so.
Okay, Mr. Waddell, any contact with anybody from Cisco on this matter?
We haven't heard from anyone from Cisco Systems. We have not heard from their tax rep in this regard. We filed a motion to dismiss some time ago, and we haven't had any interaction with them at all. So they were notified. We just haven't had any response at all from them.
Okay. All right. Well, let's go ahead and call this matter then. And this is 20 Property Tax Commission 0036 here on the motion to dismiss filed by Durham County regarding Cisco Systems Capital Corporation. Mr. Waddell, we'll hear from you at this time.
Thank you, Mr. Chair and board. I think I had a similar situation the last time I was before the board where the taxpayer actually did not show. So that's an additional basis for our motion to dismiss. Initially, we had 2 bases for our motion to dismiss. One was jurisdictional, the other one was procedural. This one is as well would add a procedural basis for the dismissal that the taxpayer failed to pursue the appeal. Obviously, this is a jurisdictional issue. The taxpayer failed to perfect their appeal by filing within a 30-day time limit after being mailed the notice from the Board of Equalization and Review. The notice was mailed out on December 11th of 2019, which would have given the taxpayer until January 10th of 2020 to actually file their appeal with Property Tax Commission. The appeal was filed on January 13th, 2020. There's no evidence or assertion by evidence in the file or assertion by the taxpayer that there was a different date of filing. Therefore, pursuant to North Carolina General Statute 15290 G and E, the board lacks jurisdiction to hear this case. And of course, the controlling Court of Appeals case is the Bass Income case, 1994 Bass Income case. So we would ask that on that basis, the matter be dismissed as a matter of law. That's for jurisdictional reasons. Then for procedural reasons, the taxpayer is a corporate entity, and the taxpayer has failed to have a representative that is identified and qualified pursuant to 150 D2 to represent the corporate entity. And so for procedural reasons, the taxpayer may not have their matter heard before this board because they have not complied with the statutes requiring an owner or a member qualifying under 15292 to represent them before the board. So that would be a procedural basis for dismissal. And then the third basis is that the taxpayer has failed to prosecute the matter before Property Tax Commission by showing up. Property tax, the taxpayer has the burden of establishing that the county has in fact done something either inappropriate or has assessed a value that is not a value that is in the true equal to the true value of money, and they have failed to do that because they haven't showed and presented any evidence to rebut that presumption that the value is a legitimate value. So for those three reasons, the county would ask that this matter be dismissed and that the taxpayer's appeal be considered untimely filed.
All right, I think, Mr. Wardell, you referred to the statute as 150. If you did, it's 105, I believe.
I'm sorry, 105.
That's okay. And all right, well, we have the information here about it being untimely, and also no one has appeared on their behalf. I don't know that we need to get into the representation of who filed it matter, unless you think we do, Steve. I assume there's, let me ask again, anybody here on behalf of Cisco Systems Capital Corporation? All right, no one here to appeal. Steve, you want to give us the information on whether or not proper notice was sent out in this matter?
Yes, Mr. Chairman, on September 28, 2021, our office sent notice to the parties of the time, date, manner, and purpose of today's hearing.
What date was that?
September 28.
Okay, okay. Any questions or comments from commissioners? Mr. Peasley?
Yeah, the no filing of an AV 14, I believe that's the second argument. Is that correct? It's no AV14?
Steve, I think it was basis of who filed the appeal was what Mr. Wardell was arguing. You want to comment on that?
Well,
Oh,
I will just
go ahead, Mr. Beasley.
I will just say the only basis that I've heard so far is number 2, and I want to explore that. The reason why I don't think number 1 applies is we don't have an affidavit. There's nothing supporting when the notice of the Board of E&R, when that was submitted. And as far as the taxpayer not being here today, this isn't a hearing on the merits. This is a hearing on their motion. They don't have to show up today. And that's why number 2 seems to be the only basis for granting a dismissal, as far as I'm concerned. But
Yeah. Well,
tell me I'm wrong.
No, I think certainly it's not here on value, Mr. Wardell. It's only on the motion to dismiss. We would not heard the value question today. Is there an affidavit in this matter, or you have anybody to testify about the notice of mailing? Anything in the file? You want to comment on that?
There's no affidavit as to when the matter was was sent out. Since this is a motion to dismiss, the motion is heard on the matters in the record. The only matter in the record is our motion, and there's nothing opposing our motion and the documents in our motion. So that's the evidence of that in the file. But secondly, if we want to deal with AB 14 in that matter, there was in fact no the owner or a representative of the taxpayer did not file the AB 14 as required by 105 290 D2 as well. So I think they're both legitimate bases for dismissing the case. There is no opposition or nothing in the file in opposition to a motion. So the evidence is the evidence that's in there, and the evidence showed there is a copy of the consent, and there's nothing to rebut that. And the notice has the date of mailing on the top of it. There's no requirement for an affidavit, but if there was something in opposition, then I could say possibly we would need an affidavit or a witness to verify when it was mailed out. But this is the standard operating procedure of the Board of Equalization and Review. And I would argue so much that this is should be accepted as a business record, because this is the standard operating procedure. Unless there is some evidence in the record contesting that date, which there is not, then that would be received or should be received by the board as an uncontested fact in the case.
Mr. Pelfrey, you want to comment on how you interpret this? I know in most cases we've been having somebody or an affidavit, but what's your thoughts on this?
I think that an affidavit or a verified complaint is typical, but that has been I don't know that there's a requirement for that. I think that Mr. Wardell is correct that if there's nothing to dispute what has been put into the record, then there's no reason to question it. That being said, it's probably a better practice to include an affidavit or a verified motion, but there's nothing there's nothing procedurally that requires that.
Other commissioners want to comment on that, Mr. Guest?
Mr. Pelfrey, if we look at the Exhibit 1 Notice of Decision of the Board of Equalization and Review, that document states mailing date December 11th, 2019 on the top right corner. This went to the Cisco Systems care of the Property Tax Alliance, who was their representative. If we go to the AV 14, which is exhibit number 2, it appears that the authorized agent is Rhonda Zając, authorized agent, signed all of these on January 10th, 2020, which would have been the 30-day date. If we then go to the only copy of a postmark, and there's not an exhibit number, but it's the last page, it is North Carolina Department of Revenue private and confidential letter. And this appears to be a metered mail, but this appears to be where the Department of Revenue mailed something to Mr. Wardell. I do not see in our files, perhaps you have it, I don't see anything regarding the envelope that the taxpayer mailed in the appeal that would indicate whether the United States Postal Service timely stamped or whether the original envelope was a metered mail. Can you tell us about that?
Steve, you may have, I guess, the best information on that.
Yes, sir. I'm
Belfry.
taking a look at what I've got. Give me 1 second to pull this up. The mailing that we have, the envelope that we received from Property Tax Alliance Incorporated has a it's not really a postmark, but it is a USPS generated label that is dated January 13th, 2020. And we have it stamped as actually received in the office a few days later on the 17th. But it does bear a date of January 13th, 2020 on the USPS mailing label attached to that envelope.
Okay, and that would have been 3 days after the due date, is that correct? This is Commissioner Guess.
Yes, that is correct. So if December 11th was the date of mailing, then the due date would have been January 10th.
Thank you.
And what did you say about that was it had a label on it, but it wasn't postmarked for January the 10th?
Yes, sir. So what I have here on the label is a barcode label that was generated by the U.S. Postal Service, and that date shows, or that label shows a date of January 13th. And we, even if it may not be actually technically a postmark, but we have treated that as a postmark for filing purposes.
It said the 13th or the 10th. I'm confused.
The due date would have been January 10th. The USPS label is dated January 13th.
Okay, I thought at first you said it was dated the 10th. That's my mistake. So that indicates it was late as well. All right. Further discussion on this matter. We have a motion. What's the pleasure of the commission?
Mr. Chairman, based on the evidence before us and Mr. Pelfrey indicating that the United States Postal Service mailing from the property tax agent was postmarked late, I would make a motion that we accept the county's motion to dismiss.
Further, do I have a second?
Second.
second from Commissioner Michaud. Any more discussion on this matter?
I'm still
Commissioner Wheeler, Vice
in,
Chairman?
well, I can't bring my memory up to discuss what Bill was talking about with the affidavits. I don't remember how it's happened in the future, but at some point in time, I do recall that the commission was sending out the word to counties that you need to include an affidavit. I'm sorry, Bill, I can't pick up the history on that in my mind and how that occurred, but we actually initialized doing that.
That has been our practice in the past. It either needs to be a verified motion or there needs to be some affidavit as to when the notice was mailed. And while the motion has been referred to as evidence, the motion is not evidence. There's nobody here to shepherd it in. There's no affidavit. As far as I'm concerned, I don't know when it was mailed. I have an assertion as to when it was mailed, and the county has the burden at this point from the motion to dismiss.
And I guess what I'm doing is wrestling with that versus, and Steve, your letter to the taxpayer dated January 21st, which is the next to the last page in the file. You mentioned the January 13 date as the date that his appeal was filed with the commission.
Yes, sir.
Yeah, I guess it doesn't change anything. It was still 2 or 3 days late.
Well, that depends upon when the notice was mailed, and we don't have any evidence of that.
So, Mr. Chairman, Commissioner Guest.
Mr. Guest?
All right. We have in the past, I will agree, we have in the past required proof that the document was mailed on time. The fact that it was printed with a date on the top of the envelope doesn't mean that it actually went out in the mail on that date. So therefore, I will rescind my motion.
All right, and so we don't have a motion now. Let me ask this. Do you want to continue this case, the motion, until Mr. Waddell can see if he can satisfy requirement about mailing date?
Well,
What's your pleasure?
if it's a jurisdictional issue, he can refile a motion to dismiss with the proper documentation at some other time. I don't see the point in continuing it. My motion would be to deny it at this point. And then he can refile if it's a jurisdictional issue. It's always available for assault.
All right.
If that is in fact going to be the position of the board, I would ask that you also make a ruling on the other two basis for dismissal that I brought forward. One was the jurisdictional issue. The other one was the procedural issue. The procedural issue is that, you know, the AB 14 was actually filed by someone who was not authorized to file it, and therefore it is not a legitimate appeal because they have not followed the appropriate steps for having the taxpayer appeal the notice that was filed on behalf of the county and mailed to the taxpayer. So therefore, the actual appeal itself is insufficient as a matter of law because the taxpayer did not, in fact, file a proper notice of appeal to the Property Tax Commission. That would be the second basis for it. I think I've heard Mr. Peasley mention that the taxpayer does not have to defend against the motion, and there's no presumption because it is a motion to dismiss. You know, I would differ in my opinion on that, but I would say that even with that, the fact that the AB 14 was filed by someone who did not have the authority to do it makes the appeal null and void.
All right, well, let's talk about the second issue you raised. I think as to for failure to appear, we don't require that they have to be here on the motion. Obviously, it's the best practice, but it's not like the direct appeal on valuation. Steve, that one, the third basis, we would not normally dismiss on. And you want to talk about the second basis, about who can file the appeal notice?
Well, just to clarify, there have been cases where a reason for dismissing an appeal on a motion included the failure of the appellant to appear at the hearing as scheduled, which is, in the administrative code that an appearance is required for a scheduled hearing. So that actually has happened in the past, even though it was a motion hearing. Secondly, I don't think that I'm prepared to comment on the clearly the AB 14 was not signed by the appellant or the appellant's attorney or by an employee or owner of the appellant as provided in 290D2. I don't. There have been recent. The recent Harris Teeter case indicates that might not matter for the AB 14 form. It depends on, I guess, what's included in that form. But the Harris Teeter court did allow for a Scrivener's exception that allowed for a non-attorney to basically fill in the blanks on a form and send that in. So I think there's a little bit more to that situation. But again, clearly, it was not signed by an attorney or by a 290D2 authorized non-attorney representative.
All right, let's see, Commissioner Michaud.
I just have a clarification in terms of when it was communicated to the counties that an affidavit was required and when was that done? That's a lesson for me, a history lesson, I think, for me. So can someone, Steve, can you comment on that?
To my knowledge, there has not been anything, written, sent out to the counties or anything like that. There was a general verbal information passed on a few years ago, at least, basically letting the counties know that if a motion was going to be filed, that the county should appear for the motion. That was certainly something that was there. But even prior to that, I think that the practice of the commission has always been to expect an affidavit, to require an affidavit for untimeliness motions. But again, I think that's different from whether or not it is legally required.
If I may be heard.
Sure.
There are a few things that I'd like to address here. The first is the county, and I've been representing the county in tax matters for almost the last 10 years. The county has never received a notice from the Property Tax Commission that an affidavit was required for a motion to dismiss, unless that motion to dismiss was based upon an untimeliness of filing with the Board of Equalization and Review on the local level. This is a matter that involves a failure of a taxpayer to file a timely notice of appeal with the Property Tax Commission. So the documents of the Property Tax Commission, that is the evidence of a failure to timely file. The only time that we've ever filed affidavits were when we were saying that a taxpayer was untimely filing to the Board of Equalization and Review of Durham County. So the evidence in the file is the evidence that is provided by the Department of Revenue. And that is the only time, when it's with the local board, it's the only time that we file affidavits. And we've never gotten any written communication, any verbal communication in my office or at the tax assessor's office that for an untimeliness matter that involves a failure to file with the Property Tax Commission, we needed to file an affidavit. I do not want to, one, appear to be dilatory. And I think the facts, I think the evidence in the file is, and I think the motion does provide evidence of what the basis for the dismissal is. I don't think that you have to have a verified affidavit from anyone at the county to dismiss the case, because the evidence comes from the Department of Revenue as to when it was received, and the assertion by the county is that it was mailed out, ordinary mail, which is the normal and standard operating procedure. So I just want to say that that has been our practice. If it's untimely with the local board in Durham, we file an affidavit. That was not the case here. And we've never been told otherwise. So I don't see how that can be a requirement if there is evidence in the record that it was an untimely filing of the AB 14, and that was communicated to the taxpayer by the Department of Revenue and counsel for the Department of Revenue.
I know that most of the
Mr. Wheeler.
affidavits that I've seen talk about the notice of decision of the Board of E&R was in fact mailed. And if you look in the earlier case we had yesterday from Pitt County on page 4, which is Exhibit 1, there is an affidavit from the tax assessor of Pitt County certifying that he mailed the notice of decision of the Board of E&R on a certain date. I know that's been a common practice of the commission for quite a while. I can't remember whether we only did it in matters of a notice of decision of the Board of E&R or not. I don't recall.
We've been doing that for a while. I would say it's probably close to 10 years.
All right, let's see if we can find a place to go from here. As to Mr. Waddell, Steve pointed out, Mr. Pelfrey pointed out that recent decision from the Court of Appeal, I guess it was Court of Appeals, about someone else filing on behalf, that probably wasn't a practice of law. So I don't know that we'd feel comfortable on dismissing it for that. For failure to appear, I don't know. That'd be up to the commission as to whether or not we'd want to do that. As to the first one, I know that in the past, since I've been chairman, which I guess is now 5 years, we have talked about the need to have someone testify as to mailing on a motion to dismiss or an affidavit in the file. As Steve pointed out, I'm not sure that's a legal requirement or one that the commission informally adopted. I don't know that we did a rule on it. I guess if the question, I guess, in my mind that I'm wrestling with is if the taxpayer is not here and contesting it, whether or not it's disputed and to the point that we need anything else there. So I guess that's what I'm wrestling with as to, do we definitely need something to show the mailing date, or is the date on that document, which could be a business record, sufficient, or just the motion? Obviously, the better practice is to have someone or an affidavit from someone at the county level about the date of mailing, because the timeliness is based upon the 30 days from date of mailing. So it is an important date. So, how do you commission members feel about this, and what should we do with this, this motion?
You know, on one
Commissioner
hand,
Gass? Oh,
I'm sorry. Go ahead, Alex.
I
Well-
saw Alex first. I'm sorry.
Okay, sorry, Terry. What I was gonna ask is, instead of dismissing this, could we continue this to next month to allow time for additional documents to be presented to us?
I would,
Well, I think we could, if that's the desire of the commission.
Well, a denial of the motion to dismiss does not preclude an additional filing of another motion to dismiss with proper documentation.
I would,
that's true.
I would request a continuance of this matter until the next hearing date so that the county could provide an affidavit verifying the date of mailing in this matter.
All right, Bill, would that be okay with you? I mean, it seems if they can do that rather than going through the motion of dismissing this one and have another file created and to do all that, it seems it would be an easier way to deal with it. Would that be satisfactory with you, or you want?
Well, if a motion to continue were put to a vote, I would vote no. And
All
my
right.
vote is to deny the county's motion. If that, you know, if that's the
Okay.
motion that's on the table.
All right,
At
well,
this
let's,
time.
let me see where we are. Alex originally made a motion to grant the county's motion, which Commissioner Michaud seconded. Alex withdrew his motion. We didn't really talk about the second. There's some issue as to whether that has to be withdrawn or not, but if you don't have the original motion, I don't know about the second. Bill, did you make a motion to deny the county's motion, or did you just were talking about it?
I will be glad to make a motion, assuming there's not a motion already on the table. Technically, under Robert's rules, once a motion is seconded, not that maybe we're not under Robert's rules, I don't know. Technically, once a motion is seconded, it is no longer the maker's motion, so Alex could not withdraw it. So arguably, that's still on the table until voted down. I could make a substitute motion, which would be
voted on first.
Let's vote on the first motion, and that way it's cleared.
I'm sorry, Alex,
I
what'd you
didn't
say?
hear that, yeah.
Alex,
I think Alex was talking about going ahead and voting on his motion, and then that will pretty much answer the question.
Yes. If my motion cannot be withdrawn, then we should vote on my motion. And
so it can be withdrawn. You can withdraw your motion, but it just requires that the second be withdrawn also, I think. Let's see if we can get there. And it seems like we either Bill wants to make a motion to dismiss. I think now Alex wants to make one to continue. So Commissioner Michaud, will you withdraw your second to Alex's original motion?
I will.
Okay, so we're back now. If Bill wants to make a motion to deny the county's motion, we can vote on that. If that passes, it's over. If it's denied, if that motion fails,
I have a
then we're
pending
back to
motion for continuance.
you can't make up. Well, you can request it, Mr. Waddell, but that would not take precedence over the a motion that we have for one of the commissioners before that. Let me see. Mr. Pelfrey, you have something you want to add?
Mr. Chairman, and correct me if I'm wrong, but I believe there was the motion from Mr. Guess and the second, and that's been dealt with. I believe that the next request that has been made from the commission was Mr. Wardell's motion to continue. I don't think that there has been any intervening commissioner motion between Mr. Guess's motion and Mr. Wardell's motion.
Okay, let's see.
So I think he's just he's entitled to a ruling on his motion prior to disposition of the case, I believe.
All right, I thought Mr. Peasley had made a motion prior to that, but I stand corrected. Then I guess you're keeping up with this. All right, then we have Mr. Is that all right, Commissioner Peasley? You satisfied? Are you okay with us voting on Mr. Waddell's,
That's
or do
fine.
you contend yours was first? Okay, all right. All right. The motion before us is Mr. Waddell's motion to continue his motion to dismiss until our next session. Discussion on that motion. All right.
Well,
it's unusual that we get-
I will just say this. Is that how we're going to operate? We're going to allow somebody who isn't able to make their case. They know they haven't made their case based upon, you know, what I think everyone has said. Okay, well, we're going to give you another bite at the apple. Now, like I said, he can file an additional motion to dismiss. I don't see any point in continuing it, but
All right, Steve, let me ask you, on the county's motion to continue, normally that doesn't come right before us. Do we need a motion from one of the commissioners and a second on that, or do we vote on the motion, request of continuance from the county?
Well, two things. If I can address another situation first, I do believe that it would be, practically speaking, a little bit easier to deal with holding this matter open to another session than to dismiss it and to refile, because then the commission would be issuing an order dismissing the appeal, denying the county's motion to dismiss. Then there would be another county's motion to dismiss, and I do think that that's a little bit awkward procedurally, but again, that's entirely up to the commission to decide. So this is just a motion like any other, which can be, you know, decided by the commission, or decided by the chair, or however you'd like to handle it. But you know, just the motion about whether or not to hold this open to another day, or, you know, hold a decision in abeyance, or however you'd like to handle that, it could be done that way.
are we going to
Okay.
allow the taxpayer to submit additional documentation and to appear at the next hearing, not having had the benefit of being here, having heard this one if we continue it? Or do we?
Certainly, they would be entitled to notice that it's been continued, sure, if they want to appear, I think. We would give them notice, would we not, Steve, if that is the
Yes,
case?
sir. We would send a notice to the parties indicating that the matter was held open until it's rescheduled, whenever that may be, November, December, whatever you'd like.
I think
Okay.
it would be much cleaner if this one is denied and they refile. But further, I will say no more.
Okay, well, under normal circumstances, the chair could decide whether or not to grant the commission. But I think since there's considerable interest in this, we'll put it to a vote of the commission as to whether or not to grant a motion to continue it to our next session. Any more discussion? Did I hear somebody? Okay, the motion is then to continue this matter until the next session with notice to of course, to the other party. Hearing no further discussion, all in favor of the motion say aye.
Aye.
Aye. I heard 1, 2, 3, 4. Okay, and Commissioner Peasley votes no.
No.
Okay, so it'll be continued until the next session, Mr. Waddell. So you'll need, I think, to come back with an affidavit or someone from your office, tax office, that can testify as to the date of mailing, and then we'll get back into the matter. And Steve, we can talk tomorrow a little bit in our administrative session, about how we can communicate maybe this out to the counties, maybe so we can make sure they're informed. All right. So this matter is continued, Mr. Waddell, until the next session, and we'll get into it at that time. Anything else?
For the board's consideration.
Okay, thank you. All right, that's the only other matter we have today. Anybody else? The other matter was continued, the last matter. Good session today, good discussion. So we have these things come up from time to time. But if there's nothing else today, tomorrow, with the first one from Henderson County, that motion was withdrawn. The Belt case, has that been officially, you've been notified, Steve, that has been settled and will not be before us?
Yes, Mr. Chairman.
And then the other case, Maslanka, was continued. And the last case, all these from Mecklenburg, the Swyman case was settled. So we'll move our Thursday session, administrative session, to Wednesday. And then on Thursday, we have AV 14s, no AV 14s and AV 63. So anything else today, Steve? Anybody else?
Nothing further for the record today, nothing for the record tomorrow.
Okay, so
Just
we'll have some
from
of those items to discuss. Yes, I hear somebody.
yeah, it was me.
Okay.
From appearances, it looks like Alex has a bright idea.
I thought
Oh.
he looked angelic.
That's that's usually me. I get accused of having a halo. When I turn on my overhead lights, these track lights in the ceiling, that's the way I look. And then, so I finally got a desk lamp over here to my right. And so I cut off that and have this on, and it works pretty well. But yeah, I've had that same experience. So, Alexandra, thank you.
I have to.
I'll adjust by tomorrow. Thank you.
I have a question.
Yes, okay.
Are we gonna live stream or record tomorrow just to say that there's nothing for the record,
Yeah, we
or
probably
should I
had.
go it? Because I have a slide that I can display saying that we're not gonna live stream due to, or that we're on an administrative session, and so there will not be anything for the record.
Let me ask
I mean, it's up to
Steve,
you. I don't.
Steve, are our administrative sessions supposed to be on the record?
There's no reason for them to be,
Okay.
unless there's something, occasionally we would put an administrative matter on the record, if there was going to be an order or a,
Vote or something.
some vote or something like that.
Yeah,
But
okay.
generally, no, if it's a discussion of, calendaring and stuff like that, that doesn't need to be on the record. And
Okay.
it doesn't
So-
need to be streamed either.
So we're not violating the open meetings law or anything if we have discussions without that.
No, it's this meeting is available to be joined. I mean, that's not a problem.
Oh, they can
so
still
there's-
join it? Is that what you're saying?
Sure.
Oh, okay, that's fine then. Good, okay. I think that.
Okay, yep.
clarified
I was
my
just
concern.
curious. I can let IT know that we're not gonna. They don't have to wait around for me to
Record.
say we're gonna be. Yeah, because there's things that they have to do for us to get onto YouTube and all that sort of thing. So I'll just
Okay.
let them know that we're not going to live stream tomorrow.
Okay, but the public can weigh in and view our session, right?
They should be able to, yeah.
Okay, good. Any other questions? All right. Have a good day. It's beautiful weather out there, I guess, all over the state and the rest of the week maybe. And so see you tomorrow morning, 9 o'clock. As I mentioned, I'll be somewhere in Cherokee at that time. Thanks, everyone.
safely.
Appreciate you. Good job. Bye-bye.
Thank you.